Tony Afram here with us today. He's joining from Zurich and Sandhausen, both places. So Tony is the CEO of a startup in Zurich. Before he was at Leica, head of the patent, the IP of Leica in Switzerland. And then he started his own company. He's currently the CEO. And he's analyzing big data on patents and trying to understand how this can be useful for patent lawyers, for examinators, etc. So, Tony, what is yours?
Thank you. Thank you very much. Thanks for that kind introduction. So my name is Tony, as Michael just said. So I'm the founder of IP Quants. As you can tell from the image, it's a Schaffhausen headquarters startup. We don't really sit on this place, but I live close by at least. So, trying to get this going. So the topic today will be extracting strategic insights from patent data, and I'll go into what we mean by patent data. Might not be what all of you just think of when you hear patent. But as every journey, I just quickly want to introduce myself. So as you can tell, I grew up in Sweden. You can always tell from my face, and that is what happened. Not really, but I studied in Stockholm, so I'm a master's degree in mechanical engineering. So, but I'm a patent attorney also. That brings us to the first topic today, right? Patent attorneys in Europe are engineers, right? Or have a physics degree. So, you know, by nature we're data-driven people, right? Which is a kind of a paradox I try to explain later. So I work for some big law firm in Germany. So I worked in a law firm environment, and then I moved to Switzerland around 2008 and worked for T Connectivity, formerly Tyco Electronics. So that's how I got my in-house experience, and my latest position was the Chief IP Counsel, as Michael said, for Leica Microsystems, which included global responsibility of patents, trademarks, so on. Most of the people know Leica probably from the cameras these days, right? So that was a trademark we owned at Leica Microsystems that I had the honor to defend and to monitor their portfolio around the world. But despite having such a great honor and pleasure, I said let's start from square one. So I left last year in April and founded IP Quants. And what drives a guy like me to do that, right? Because everything was great. I have 3 kids at home, a lot of responsibility. Why do you start from scratch? So as I said, like if you sit in these meetings with CEO or VP or whatever it is, it's usually the legal guy that cannot justify their decisions by data. If you think of it for a second. I mean, even HR people, and I don't mean it in a bad way, they will tell you fill out that form online, and they came back with some KPI because they analyzed it on some metrics, right? But the legal guy, we say we need to litigate for 3 million in the US, and then the CEO says, okay, what's the chances? We believe we will win. I spoke to outside counsel. We think the chances are pretty good. They will rip you apart, right? That's not the answer they want to hear when they can measure even a candidate with data. That's not a good answer in this day of age to give back. So while in the US they're further ahead than here in Europe, I say, okay, let's try to do something about it. So because after all, we live in a data-driven world. I don't have to explain this to most of the people here, right? Because medicine, any industry really is being transformed by data. Right? So doctors, even when they were hesitant a couple of years ago, they now acknowledge they should use algorithms to analyze X-rays, etc. We don't even discuss this anymore. So just to make this bridge, what could a legal data-driven world look like? Let's just look at some examples in other industries. So if you think of sport, which is a fantastic example of data-driven. So basketball, right? We all know the movie Moneyball, we all read the book probably. So, I mean, they even track every move of a player these days. There are cameras all around, not just for the TV stations, right? There are cameras just tracking how often they dribble, was an opponent close to them before he shot or before he had a pass. So they can dissect the court and give you probability, what's the highest probability to score, and what's the best quality of a shot in which square you should be. Now that's what I call data-driven, right? They don't leave much to chance. If we think of motorsport, another great example, right? I mean, if the track temperature increases, they will be able to tell you how it impacts the performance of the car on the track. You need to change the tires. I don't know how many you like to to watch Formula One. I'm one of those weird guys that likes to do it, but it's always fascinating. So let's try to make this bridge a bit to the legal industry. So most of you probably know that you can analyze a patent office, high-level statistics. Once a year we read it, all of us, some data. IBM usually comes out on top, or some other big companies. We know how to analyze patent documents themselves, right? You can analyze for trends, what technology focus does a company have. But there's a little bit more to patent data, right? What about the correspondence between the patent office and the attorney? Right? What about the court decisions? What about the correspondence between the appeal members of a board and the lawyers? Because if we just analyze the decision, that's just, on a summary, it's decided. But it could be interesting to understand what happened on the way there. So this is how we look at it at IP Quants. We want to really quantify all of this. And as everything, you've got to start somewhere, so we focus on digitizing the European Patent Office. So that's where we're starting. So, because if you break it down to its smallest element, if you want to get a patent, at the end of the day, it's a negotiation between the patent attorney, like I am, and the examiner. So yes, every case is unique and there's the law, but at the end of the day, there are two human beings gonna discuss, should I get a patent, yes, no. The examiner will say, you can't get a patent maybe because, look, this is prior art, whatever you invented, it's not novel, it's not inventive, right? And the attorney will do everything for their client to try to win the case, right? And like everything when human beings are involved, we will have a different understanding of the law. Right? In theory, it should be easy, right? I mean, there are paragraphs, but we all know it's not. Okay? So, it would be good to have a strategy when I go about winning a patent or getting a patent, right? And not just every time start from zero. Because if you think of it, patent attorneys, as I said, are engineers and so on. So we grew up with data, we like maths, those kind of things. But now we come into this industry, and what do? There isn't any data. We reinvent the wheel every time with new arguments, but do we really have to? So before I explain how we try to solve all of this, just about us at IP Quants really quickly, so I spoke about myself. Gianluca Tarasconi, some people might know him, I think he gave also a speech here in the past. He's our chief data officer. Gianluca is mainly known for that he also found some issues sometime in the raw data. In the raw data actually that the European Patent Office sells. So he has lots of experience on innovation analytics. So brings this deep knowledge of the data we're analyzing. And then we were lucky enough to be able to recruit away Vasilis from IBM last year. So he was with IBM in Zurich, and he's our CTO. So what we try to explain here is like, it's my belief at least, you cannot just solve this problem with the legal guy, right? And it's also not enough just like the data science guy. You gotta have also you have to have all three in my opinion. And we will see what else happens down the road as we grow the company, but you gotta start with all three because the way we dig into the data is so deep, you really have to understand every piece of it from every angle. So before we could start with all of these nice things, strategic insights we want to get to, there was no data. I mean, there was data, but if I want to understand if Mauro would be a patent examiner, like, okay, how does he usually perform? There was nothing. We know there are like millions and millions of patent filings over the last couple of years, and each patent filing has hundreds sometimes of pages associated with it before it gets granted, but there's just no raw data there. So, which is a bit different to the US, where in the USPTO, the European Patent Office, you can get some data about examiners. Here there was nothing, so we said, let's do it. So before we could start analyzing anything, we just had to build their data set ourselves. So we buy some, we crawl the internet for public domains. And this is really, as also Michael's introduction kind of said, we really deal with big data. So before we had a single user, we had mountains of data, and 40 plus servers running, right? And nobody knocking on the door here saying, hey, I want to buy it, because they don't know that it even existed, right? So you gotta have some patience also building these things. So obviously, you know, we tap into public data sources. Some we buy, as I said, some is just unique, the way we know where they are, how we retrieve them. Then you got lots and lots of unstructured data, and then you start building your processes, right? And then you start building your entity recognition algorithms, right? Because yeah, there are lots of APIs out there to extract name, city, country, and those kind of things, but what about a legal article, Article 56? No, it doesn't say anything to anybody outside of the patent world, maybe, right? Article 54, burden of proof, many, many legal topics that you want to understand and connect the dots. This just wasn't there. Something we had to build before we could start really playing with all of the data that we identified. So the first part of the company, I would say, and this of course started before I left and was started to analyze, but since April last year, 2018, this is what we've been busy with. And this never stops, I have to add, this never stops. This just grows and grows, and it never stops. So we took a decision to go back to 2007 for patent applications at the European Patent Office for various reasons. This is enough. So if you just look at those 2 million plus patent applications, that's just a patent that some of you might recognize, right? That's just, but underlying to those, there are 100 million plus other documents you might want to analyze and look for insights. And I'll give some examples what you can do with that. And the way before we can analyze, we have to, of course, process the data. You know, it's OCR at scale, data processing at scale. So we break everything down in pieces. So we break everything down in snippets. So, and then we load our databases and start analyzing. So at some point you have 1 billion plus data snippets to work with. And again, this doesn't stop. This is a continuous process. So this is what we were busy with in the first phase. Just to get to the second phase, which really is where you know, ideally I wanted to do from day one, but obviously it wasn't possible. So then, once you have processed the data, and you structure it in a way that you can extract relevant insights from, that's when the fun bit starts, right? And then of course, you have to make this accessible to the user, and there are various ways how you can make it accessible, either through like we have a platform, you log in a web browser-based system, or in the future there could be other ways of distributing this to the users. But before we take some real example, I'd like to really try to make this connection again with the real world. So let's say you just bought a sports car, 1 million plus, and you're going to drive on the East Coast. There are maps out there that can show you, where car theft has happened or where cars got damaged in accidents and so on. You're probably going to look up a strategy wherever you're going to travel, and you might still need to go there, right? It's not going to stop you from going to New York, but your mindset will be different approaching this task, because you will build a strategy how you will get there. I think there's not many industries these days, or many behaviors, where we just do something, okay, here you want 100,000, you're going to go travel around the world. I mean, the first thing we do, we look at the map, we try to find a hotel, we lay out the strategy, so to speak. Right? But in the legal world, strangely enough, we file a patent and we'll see what happens. Right? So this is some of the unique data we have been able to create. Now I'm going to show you a couple of examples. So every dot here you see is one patent examiner at the European Patent Office. So this is preliminary data. We're starting to analyze it in deep now, and we're going to publish some papers also down the road. So what you see on the x-axis is the number of patent applications they've been responsible for. And on the y-axis, the grant rate, the average grant rate. So between 0 and 1, so 0 to 100%. So just to give a quick example, this examiner here, very experienced obviously, 280 roughly, but has an average grant rate of 28% only. Now, before this, you would just go file your patent and get started and see what happens. Okay, but you don't know usually attorneys would like to know, who am I dealing with? Again, it's a negotiation. That's how I break down the problem.
Sorry, Tony, can you explain again the axis?
Yeah, so this is how many patent applications they have been responsible for. We have set some filters behind the scenes here. So we exclude cases that are not decided yet, and so on. But this is 270, 80 roughly cases have been examined by this individual. And if you analyze the outcome of those, grant yes, grant no, 28% got a grant no roughly from this. It's rather low.
So if you apply basically and you get that guy, basically you are very unlucky.
Well, I'm glad you said that. Or you could be very lucky. Because I would argue if I get a patent from this guy, it's a higher quality patent. Right? So
Well, it depends, right?
it depends.
If it's bashing everything just for the sake of bashing, or if it's actually bringing more details on the table so that you can refine your patent application.
Well, ideally you don't want to refine it too much, right? Because it's too limited. But of course, if you get somebody that grants 90% of them, I mean, you better look 3 times, because I wouldn't trust the situation then that something goes between the cracks, right? Yes?
Is the grant rate generally normally distributed among different domains? I mean,
We
in
have some
pharmaceutical,
examples.
biology, it's the same, or,
Yeah.
or the domains where the grant rate is systematically lower or higher?
Yeah, that's a good question. We have some slides coming after this. So indeed, within a subsector of this technology field, you see up there it says IPCG, which is a particular technology field.
Okay.
Within a subsector, it's pretty low, because its software-related patents are in this sector. But you will see also within that sector, there's a big variation. So yeah, you could be unlucky or lucky. It depends, really, right?
So you do actually know who these guys are?
Yeah, we do know.
And that's public.
It's public data, and you just need to know where it is.
So actually, it's public data that this particular examiner is accepting more than others.
No, that is what we created, this statistical view.
But I mean, you can know, so you just
So
go
because-
through the data and you see the name coming.
Correct,
Okay.
correct. That's how.
Have you shown that to the patent office? To make sure you actually inform us.
So that's what many of our clients tell us also, and we're happy to talk to them. We tried to contact them once, but they said wait for a request for proposal and then we can talk. We're here. I'm sure they will come one day.
How do you interpret the ones that are 0 grant rates?
So that's another interesting interpretation here, right? So because attorneys will tell you, yeah, the critical guys, because not everybody believes in this. It's like any industry, try to come up with something. Every case is unique. The data won't help me. Okay, but how come then that the fluctuation is so big when they're less experienced? And how come you don't have such a big fluctuation? Because you can clearly see there like some kind of pattern evolving here, right?
And one with 150 and 0 grant rate is
Yeah.
following.
Yes, but then the guy you have just mentioned would be an outlier there, because all experienced guys are more or less
Yeah.
up there and he's unique.
You won't believe how many times I went to completely different law firms and they'd say, show me that guy, that examiner's name. And that's really interesting, right? Because it seems to be 1 or 2 or 3 within each domain that people have similar issues with, right?
Here you're not considering that the attorney is also an important factor. Because one thing I've submitted several patents, it's always very unclear to me, when does the process stop?
Yeah.
Because at what point does the examiner say, now we stop, it's no, and I'm not coming back with my decision? Because it seems that you can always go back and say, yeah, we're going to refine this and that, right? You ask questions. So I suppose there's also something that has to do with how the attorney is sort of letting go or continuing to.
Well, the attorney will always ask the client, can I file another one? And if we pay the bill, they will do. And unfortunately, the client doesn't know. Is it okay to file another one or not? Because they will be like, okay, but tell me, dear attorney, what should I do? We think it's worth to risk another one.
Say that.
But I'll show you some statistics that will help you with that in the future. So now you have two different technology fields, and you see this is IPCH. We'll not go into the details what it is, but you see with experience they're all trying to, right? Doesn't fluctuate as much anymore. So maybe it doesn't matter so much which attorney you use for prosecution. And again, there's more work needs to be done, right? Because we're not talking about the quality of these patents at this stage yet, right? Because some industries, I can tell you, it's pretty easy to get a patent. If the attorney doesn't do a good job, just puts in features, you will get something. It might be worthless. So we're not talking about the quality just yet. It's just some observation, right? Because if I have this strategic approach and build my map, and I know before I start now the process as you described, and know who I'm dealing with, I can prepare better. Right? I can start working with the data and not just with my gut feeling. And there's nothing wrong with working with gut feeling. So if I got an experienced attorney and the data, that's a great combination, I think. And interestingly enough, a lot of the big firms get in touch with us because they see that. Right? So now this is a subsector. It's G06F, it says at the top, within the G. So this is clearly computer implemented invention. This is a very, very tough space to get a patent in. Right? But even here you see it's not impossible. And even although now we're analyzing a cluster, a subcluster, you can still see big differences. Right? So it might indeed have something to do who examines your case, but unfortunately you cannot decide who will take your case. There might be some approaches to that in the future, but still it's worth knowing who you're dealing with. Right? If you have a negotiation, you want to know who you have across the table. And this is another subsector. It's more like chemical, pharma related. You see, it's, once they experience. So if I would be able to choose one, I would have given an experienced one. Or if you know how the process works, an examiner is also part of an examining division. There's always one supervisor. Now you could go back 4 times, yeah, but maybe the data says doesn't help with this guy, so I would just try to get oral proceedings, as we call it, in front of the entire examining division right away. So this might change your behavior, how you approach the case in the future. You might just deal with it for another 2 years, back and forth, or you just tell the attorney, no, I don't think, every case could be different, but you could say from the data we believe, let's just bring it to the entire examining division and get this over with. So here you have some names now of actual examiners. Again, for the first time, and this examiner, doesn't really matter who we're talking about, but he has a grant rate of 73%. It's pretty good, right? Probability you get a patent granted is pretty high, but still he's in the bottom 43%. But so what we try to explain is like, even if you look at all of your patent applications you have done, of course it's just a subset, and you will not get a complete view of the world. So you always have to kind of understand where does the examiner sit on this. So that's just, out of the gate, trying who you're really dealing with. Other type of insights is even examiners cite what we call case law. So, decisions might go to the so-called Board of Appeal at the European Patent Office, and then that appeal board takes decisions, and then we try to adhere to them. So here you see, again, there are some filters set behind. There's one technology field. On the far left, you see it's 57% average grant rate for this tech field. And yes, I could also tell you when an interview with an examiner was involved, what the grant rate is, versus if there's no interview, because we can tell from the data, when did an attorney speak to the examiner? And how did that impact? So in your example, again, the data might suggest this examiner is probably even more reasonable. If you speak to him, please do so. Because what we have to think about here, and this is what I make very clear, is that we're also going to help the poor examiner, right, who gets flooded with the same arguments every time. Right? There's a big issue about workload, etc. But if the people don't know what's happening and I go with the same every time, of course the examiner will cite the same passage every time back to you. So, interesting thing here is that what gets me particularly excited, maybe in the future we can even have a leading indicator. Because what happened here now is you see the grantor dropped to 5.6% for these cases. So what we've identified here is like when an examiner cites a particular case law decision from the Board of Appeal, you're in big trouble. Because those examination procedures where that was cited didn't end well. Right? So you could now in the future flag to the attorney, be careful, whenever we saw that this got cited somewhere else, it didn't end well for the patent owner. And you should probably know this, right? It's about not reinventing the wheel. The paradox here is, if you come to a patent attorney, the first thing they will recommend is that let's do a patent search, because maybe this exists already, right? We all know that situation. We shouldn't reinvent the wheel. Yeah, but anyway, I can say this because I'm a patent attorney, but we do that mistake every day, right? We just start from zero, as we've never discussed with this guy before. Of course, the technology is different, but there are some elements that are similar. Otherwise, you wouldn't have these kind of differences either. So another point you can see from the data, and let me explain a bit here. So this is one particular examiner at the European Patent Office. And these numbers down here mean how many, we call them communications, does the examiner issue. So when they review a case, they will issue an official communication. So they will tell you in this letter basically, no, you're not getting a patent, yes, you're getting one. So exactly what you just said. This can happen a couple of times. There could be cases where he never issues any, he grants it directly, or you drop the patent before he got to start. There could be cases where he launches at least one letter, cases where he has issued at least 2 letters, and so on. So the line shows you obviously 100% of the application this examiner has examined, which are 259 in this case, have at least 0 letters. That's clear, right? So we start there. 94% of the cases he examined have at least 1, but now you see the drop. This guy's patience was over after the first letter almost, right? Only 8% of his cases would still show that he issued 2 examination letters. So it's a bit difficult to understand the process, but you just said it nicely, you gave me that. We didn't discuss it before. Usually you do it 3-4 times. People say, yeah, we can do another, we can do another. But no, I mean, with this guy, you're in big trouble after the first one. You better get your stuff together right away. Because yes, when you get to the granted is 57%, but that data doesn't really mean anything because there are only 21 cases that survived to that stage. He had initially 260, 244 years still, and then, you know, this is just, you can ignore it. Now, you could argue, of course, how does it look now compared